Understanding protective orders in Indiana. A protective order is something that a person can file asking a judge to grant an order of protection that would prohibit a certain individual from making any sort of contact with the person that filed that protective order. So who can file for protective order in Indiana? If you have been threatened or the victim of violence and that person that perpetrated that violence was a family or household member, then that person can file a protective order against that person. Additionally, anyone that has been subject to repeated acts of harassment or stalking can also file a protective order. Now, for harassment or stalking, the person does not have to be a family member or a household member. It can be anyone from the general public. For family or household member, that person has to be related by blood or marriage or living with you at your residence. Now, what is family or domestic violence? In the protective order world, that means that anything where actual violence has been perpetrated, threat of violence has been issued, or something has been done to place you in fear that your safety is at risk. Next, we'll turn to stalking. Stalking is defined under Indiana law as a knowing or intentional course of conduct involving repeated or continuing harassment of another person that would cause a reasonable person to feel terrorized, frightened, intimidated, or threatened, and that actually causes the victim to feel that terror, frightened, intimidation, or threatened. And finally, we'll turn to harassment. Under Indiana law, harassment means any conduct that is directed towards a person that includes, but is not limited to, repeated or continuing impermissible contact. That would be contact that causes a reasonable person to suffer emotional distress, and that person actually suffers the emotional distress. Indiana courts have defined a course of conduct to involve 2 or more incidents. So when a petitioner files a protective order, they must allege the incidents of which they're trying to get the order of protection for. After that order has been filed, the judge can do one of 2 things. The judge can either grant the protective order without a hearing, which is called an ex parte motion for protection, or the judge can set it for a hearing. Now, in either event, you can still fight the protective order. If the judge grants it ex parte, you have 30 days to file notice to the court that you are demanding a hearing. The other option, where the judge sets a hearing on the onset, you will receive a subpoena in the mail, and then you just need to show up to court that day to challenge that protective order. Now, it's always important to have an attorney with you if you're going to challenge a protective order for a variety of reasons, mainly because a protective order hearing acts like a mini trial. The petitioner has to prove his or her case, both the option to present evidence, call witnesses, and testify themselves. And it's always important that if you're fighting a protective order, to have a skilled attorney on your side that can fight the allegations that the petitioner is alleging against you. If you have any questions about protective orders, if you're facing protective order yourself, or if you're in need of protective order, give us at the Marc Lopez Law Firm a phone call, 317-632-3642, and remember, always plead the fifth.